Welcome back to the channel and thank you for watching. So in this video, I'm addressing a very specific issue, so you'll have to bear with me for the explanation. Now, the topic of this video is why are the jury not permitted and in fact expressly directed not to research a case whilst they are hearing and then go on to deliberate it. And there's a lot of reasons for that, and I will address one or two of them that are particularly important in this video. First and foremost, the jury are to deliberate a case based only and solely on the evidence that it hears within the four walls of the courtroom, and that's for a very important reason. Because there are rules of evidence, there are rules of procedure, and there are certain witnesses that come forward and their evidence is tested. And it's tested under very specific conditions, under controlled conditions, and those questions can be rephrased, objected and directed and so on, so that the jury are directed to consider only that evidence which falls within the law, within the parameters, within the procedure that they are supposed to consider. That is the normal reason that most people understand. But there is another reason, a very important reason, which probably escapes most people with due respect. And that is as follows. The media will usually turn up at the start of a trial to report the case against a person. Notably and recently in the UK, against journalist and comedian and presenter Alex Belfield. So I noted that the media turned up and reported various sections of the prosecution opening speech against Mr. Belfield. Now, as the prosecutor quite rightly observed during that speech, that this is not evidence. This is the prosecutor's overall description, explanation of what they say the case is about. But it's not evidence. And in fact, anything that the media reports about such an opening speech is not evidence. And it goes further than that, because even when the media then go on to report what certain witnesses say in their evidence in chief, which is their primary evidence, whilst that is indeed evidence, it's not the whole of the evidence. It's only part of it. It might only be one witness. It might only be the evidence in chief of one witness, as against the evidence in chief with the full cross-examination, i.e. the testing of the credibility, the reliability, the consistency or the inconsistency of that evidence. And unless one were to listen to the entirety of that evidence, i.e. the entirety of the evidence in chief and the cross-examination tested of that evidence, then one cannot be entirely sure as to the full meaning of the evidence given by that witness. But it goes further than that yet still. If one were to research a case and were to read media reports or media opinions, which shouldn't really happen. It should be neutral, fair and accurate reporting. But let's say that opinions may sometimes creep in, albeit accidentally. But there will certainly be some opinions by members of the public in response to certain articles. And if they research such cases, there will invariably be opinion pieces and opinion comments that such jurors, if they were to research such a case, they will see such opinions on these things. Now, you will note that when I comment on a live case that I don't generally express my opinion, even though I'm allowed to do so because I am, as a legal commentator, as a barrister, I am permitted to express my opinions. News reporters are generally restricted to fair and accurate reporting, but legal commentators are generally permitted to express an opinion. Historically, barristers were prohibited from expressing opinions. That's no longer the case, even if it's a case that we are actively involved in, which even I find a little bit strange, but those are the rules and we are permitted to do so. But coming back to the point, if a jury were to research any case that they were going to deliberate, they would invariably come across snippets, and that's the key point, snippets of reporting on the opening speech, which is, this is what the court was told, albeit not evidence, it's what was told in the opening speech. This is what the court heard from X, Y, or Z witness in their evidence in chief, albeit not the cross-examination necessarily, if it wasn't reported, not the cross-examination points, and certainly not in any one article the entirety of the case. So if a juror were to research any case at all, they will see one snippet of information, of reporting from whichever news company or whichever individual member of the public, or even someone such as myself. So even if they were to research it and find my opinions, if I were to vouch such an opinion, they would only see a snippet of the case. And that is not how the justice system is supposed to work. The jury are supposed to hear the entirety of the case, presented and represented fairly, accurately, from start to finish, prosecution and defense, or plaintiff and defendant, or claimant and defendant, from start to finish, in its entirety, with no opinions, with no misquotes, with no small windows of evidence reported, just the entirety of the case, so they can then go and decide on it fairly and without prejudice, without malice, without influence. And that, my viewers, is why a jury are not permitted to research a case. So I hope you found that interesting. Please do leave me any thoughts and comments in the box below. Please do like the video and subscribe, as I always ask you to do so, only if you found it interesting and informative. And as always, thank you for watching.